Good afternoon. My name is Joseph Kearney, and it's a great privilege for me as Dean of Marquette University Law School to welcome you to our Nies lecture on intellectual property. We are so grateful and delighted that all of you are here today for this occasion. Through this lecture series, begun more than 25 years ago, we remember the Honorable Helen Wilson Nies. The late Judge Nies served as a judge of the United States Court of Appeals for the Federal Circuit. Even now, more than a generation after her judicial service and lifetime, Judge Nies continues to be recalled within the intellectual property community as a very generous individual and a hardworking, accomplished, and modest judge. The idea for this lecture came from Craig Nard, a member of our faculty at the time in the late 1990s, who subsequently moved to Case Western Reserve University's law school near his wife's hometown. We are no less fortunate in our faculty today with Professors Bruce Boyden and Kaylee Murray serving as co-directors of our IP program. Their leadership of Marquette Law School in this sphere engages with professors and practitioners across the nation, even as it maintains a relentless and impressive focus on our students and their development. We also welcome this year a new faculty member with an interest and expertise in IP, Professor Jason Reinecke. Speaking of Marquette Law School faculty, present and past, I turn to this year's Nies lecturer. Eric Goldman is Professor of Law, Associate Dean for Research, and Director of the High-Tech Law Institute at Santa Clara University. His interests include internet law, intellectual property, and advertising law. His intelligent writings, both short form, such as blog pieces, and longer form in academic publications, have made him a recognized thought leader in California and beyond. Professor Goldman is a California kind of person, having received his BA, MBA, and JD at UCLA, and practiced law in Silicon Valley. And in any number of respects, it seems to me right that he should be there. Yet it is also right that he should be here in Milwaukee and at Marquette from time to time. For his first full-time teaching job was here at Marquette University Law School from 2002 to 2006. Professor Goldman was assistant professor of law then, and he left us on the best of terms. He is back, if briefly, for this year's Nies lecture, bringing good cheer from sunny California. Generative AI is doomed. Please join me in welcoming Santa Clara's, and if I may, Marquette's Professor Eric Goldman.
Oh my, it's such a great honor to be back at Marquette and to do this year's Nies lecture. Many years ago, when I was here as a professor, I helped invite speakers to be Nies lecturers. And so it's a little surreal for me to now be on the other side of the equation. It's also great to be back in Milwaukee, weather notwithstanding, and at Marquette. This school holds a special place in my heart. Indeed, perhaps a little known fact is that I named my son after Marquette. His middle name is M-A-R-Q. Thank you to Dean Kearney and the Marquette Law faculty for the invitation to speak, and I'm so honored that so many of you came out today to join us. Okay. In deciding this year's lecture topic, I thought I'd take the well-worn, well-traveled path of predicting gloom and doom. Dire predictions about the future of AI are a scenes affair of the genre. And I'm going to deviate a little bit from the normal way we think about AI and doom. I want to talk about what I consider to be the precarious future of generative AI. Now, before I go any further, I want to talk a little bit about the images that I'm using. These are an integral part of the presentation. And as you probably already guessed, or as indicated at the footer, these images were created by generative AI, but it's not a project I could have done myself. I actually had help doing this One of my former students, Jess Meyer, now teaches Santa Clara Law's AI in the law class, actually helped do the work because all I could do is come up with the concepts of what I wanted the images to be. Um, and then she had to go and do, and you can see the concept, like I gave her that very general statement. She then did all the prompt engineering. And the way that she did it is she took my concept and then she drafted up something and then ran it through Gemini, an AI tool, to come up with a prompt that she ran through DALL-E to generate the images. And then she kept interrogating the DALL-E to refine and modify the images. So just to give you an example of what that looked like, this is the actual prompt that's sort of a slide that's coming up. You can see this is not the general concept that I gave. That was at the very top there. You can see that it turned into a actually fairly complicated effort. So what that means is that the images that I'm going to be using today are actually truly a joint production of humans and machines. The humans, Jess and me, the machines, DALL-E and Gemini. Um, and not all the images achieved my vision, but I've kept everything that we ended up using and that wasn't perfect, in part to show some of the challenges and limitations of using generative AI in order to produce the images. Um, I will note that Jess sometimes did override DALL-E's tendency to show white males as people, but you're going to see some of that here. I left that in to show you, again, some of the images, some of the limitations. I got actually more to say about the images coming up. Okay, let me get to my big general thesis here that I'm going to lay out for you over the course of the talk. We're at the beginning of what I'm going to call a regulatory tsunami, a metaphorical overproduction of regulation governing generative AI. It's my hypothesis that the regulatory tsunami will severely stunt the innovative trajectory of the technology and potentially wipe it out entirely. Let me tell you how I'm going to get there. I'm going to start by defining generative AI as a subset of this thing called artificial intelligence, or AI. And I'm going to explain how we're at the beginning stages of a new era of innovation and communications. I'm going to then really get to the heart of my talk, which is to explain why I see parallels and differences between how the regulators are responding to generative AI and how they respond to the internet when it first came to the public sphere in the 1990s. And because of things that are different today, generative AI is not going to get the same regulatory treatment. And I believe that's going to, the severity of the response is going to lead to a different outcome. So I'm going to describe then, after laying out the similarities and differences with the AI, I'll talk about what those consequences are for generative AI and for all of us. Okay, so let's start by defining our terms. I'm going to define the term generative AI, and you know how I did that. I went to ChatGPT and I said, define yourself. And here's what it told me. It said, generative AI refers to a subset of artificial intelligence, AI, techniques that involve creating or generating new data, content, or outputs that mimic human creativity or problem-solving abilities. Unlike traditional AI systems that are based on rules or predefined responses, generative AI models are trained on large data sets and capable of producing novel outputs that are not explicitly programmed. These novel outputs could be text, they can be images, they can be video, they can be audio, they can be software code, and a lot of other things as well. And many of you have had this firsthand experience with the text generation. You go to a chatbot and you have a conversation that feels like you're talking to a real person. It's a conversational style of generating the text. There'll be even polite and friendly banter. And as you saw from the slide I showed you with the prompt, that often the quality of the output depends on the quality of the prompt itself. The more you're clear about what you're trying to accomplish, the better the outcome. And so what a lot of us are going to have to do over time is learn prompt engineering. We're going to have to get better at asking the right set of questions. And indeed, I think it's going to become more valuable over time to know how to ask the right question, than it is to know the right answer. Think about like the old Trivial Pursuit days, like you were tested, did you know it or not? But now the Trivial Pursuit, like, can you ask the right question in the chatbot? Okay, so generative AI is just a subset of the overall universe of things that we call AI. And most time when we think about AI, we think about general artificial intelligence, which is the kind of thing where the machines are thinking for themselves, or it's AI that controls physical machines like murderous drones. And so I'm not talking about either of those. I'm talking about generative AI, this thing that we use to create outputs. And those themselves, those outputs create many risks to society, but it's still things that humans are controlling, and it's still not leading inherently to murder. Okay, generative AI may be something that you think of as new, but automated content generation or creation has been an integral part of the things that we're using on a regular basis for a while now. Things like Adobe Photoshop offers a number of ways that it's automated in its production. Google Search will give you predictive guesses at what you're trying to search for. Gmail will give you predictive replies about what you might respond with. These are all things that we would consider to be analogous to generative AI. But in 2022, we had a moment with generative AI. OpenAI, the vendor, made available DALL-E 2, the image generator. They made available ChatGPT 3.5 for the chatbot. And these were both really powerful and easy to use tools that would lead to high quality outputs. So because of the availability of those tools, we now had, I think, a much higher public awareness of the tools and just in an incredible amount of adoption. So millions of new users started using generative AI in 2022 and shortly thereafter. And I'm going to refer to the developments, the combination of DALL-E and ChatGPT launched in 2022 as the generative AI epiphany. Okay, at the same time, when we had the generative AI epiphany, we also exacerbated many of the fears we had about technology generally and about AI specifically. Teachers worried about the integrity of their graded assignments due to possible cheating by students using generative AI. Employees wondered if generative AI would moot their jobs or replace them. Misinformation researchers predicted a flood of junk content being automatically manufactured. Generative AI epiphany was also quickly followed by major technological launches from other generative AI vendors, and a flood of investment capital has been poured into the generative AI space. So for that reason, I think the generative AI epiphany is going to really be marked as, by historians, as a key turning point in human-machine interactions. Now, when I define generative AI, I've been defining it as this broad function of producing these automated outputs, but I want to break that down a little more specifically. There are two functions of things that generative AI can do and how it's used. So the first function I want to talk about is generative AI as a way of manufacturing new and expensive works. And I'm going to call this a content generation function of generative AI. Now, there are virtually limitless number of ways in which content generation can produce better outputs at lower costs than humans do. Some of the examples you've surely heard about: coders can use generative AI to write and debug code. Job seekers, including many of our students, are using generative AI to write better cover letters and increase their employment prospects. Lawyers are using generative AI to generate outputs, at least the first draft of them, like contracts or legal briefs. But you have to watch out for the hallucinations. Some of you have heard of the stories that not all the facts in those are correct. So consistent with these examples and many others, generative AI has exposed in part how many of the content production tasks that we do are somewhat routine in nature and actually lend themselves to being outsourced in part to the machines. And by doing so, these outsourced processes reduces the total labor required to reach particular types of outputs. And I think about the analogy, some of you had this firsthand experience about the launch of e-discovery, which displaced a lot of labor that was being done by lawyers because of the fact that the machines was now producing the work. We also see another analogy, something obviously that Wisconsin experienced firsthand with the robots taking over the jobs that were in manufacturing. The labor got displaced by the availability to outsource to the machines. So there's no question in my mind that generative AI is going to have similar effects, that it will displace some of the work that's being done, and that's going to have both distributional and have emotional consequences or psychological consequences. Although I don't think anyone really knows exactly what those are going to be. We know they're coming, but we don't know exactly what they're going to be looking like. Um, so either way, I think we're going to have to rethink how we train and educate our students and how we train and educate workers to be responsive to the needs of future employers. But our instincts might suggest that this transition is bad, but I'm going to suggest otherwise. And I think that there's actually some important benefits that are going to be produced by the outsourcing of some of these content generation functions to the machines. Now, certainly where the machines have a relative comparative advantage to humans' content production, that means that the humans can redirect their energies to other parts of the value chain or other parts of the production process. So we've seen this in other types of labor-intensive industries where automation has enabled the workers in that field to be doing different things that add different kinds of value. Increasingly, what we're seeing in industries like agriculture or manufacturing is that the competitive differentiation comes from the employee knowing what to do. So it's not just in the process of making the thing, it's knowing what to make or how to better make it. That's where the real value comes from. So where generative AI is doing this displacement, it also creates opportunity for new creativity, new innovation, where people are going to be adding different value at different parts of the chain. It also opens up content production to individuals who have historically been excluded by the high cost of producing content. So I mentioned how we as lawyers can use generative AI to prepare first drafts of materials. Well, everyone can prepare a first draft of a contract or a brief or any document that they're working on. And in many cases, those are going to be high quality. They're not perfect. They're only a first draft, but they might move the process forward faster in ways that would have excluded people because they didn't have the expertise that's only produced by significant training and practice. So let's talk about an example of how that looks, how somebody can get access to skill sets that was previously foreclosed by the high barriers to entry. This talk is a microcosm of that. These slides, for example, reflect the vision that I have, but I have zero artistic talent whatsoever. There's no possible way that I could have the images complementing my talk if I had to do it myself. So I wouldn't even considered it. I would have gone and copied and pasted some free to license photos from the internet. I actually, when I was looking for some wardrobe to complement the talk, which I struck out on, I was on Etsy and I was looking at AI, and I could have put together an entire talk from just the products that are available on Etsy. There's a whole lot of people who hate AI on Etsy, and there's some people who love AI on Etsy. I could have put together. But instead, I came up with my own custom crafted set of slides with my help of Jess. I couldn't have done it. And I'm hoping that in the end, the output, the combination of the talk and the slides leads to a better, more enriching experience than could have been produced otherwise. So if you think about me as becoming a pseudo artist, you can think about non-artists becoming artists and non-writers becoming writers and non-coders becoming coders. And by expanding the pool of who can take those status, we open up the door for a larger pool of people who bring different talents and perspectives to bear. So we're opening up a whole new range of interactions with creativity and innovation that comes from the diversity of the perspectives of the people involved that were foreclosed by the high cost of content production under the current model. Okay, I want to talk about another function of generative AI, and this is the way in which it helps people research and understand topics of interest. I'm going to call this the research function of generative AI. And generative AI can surface insights and resources that don't necessarily show up through the traditional keyword searches. This makes generative AI an important complement to the daily search engines that we use. And in fact, I think it's exposed some of their limits as a search tool. As you know, both Google and Bing have added generative AI supplements to their keyword searching process, showing in fact that there's some additional value that's being created above and beyond what they've done in the past. To me, I think that generative AI is going to become an integral part of future research processes going forward. And anytime we create a new method of doing research or searching, that has important society-wide benefits. I've distinguished between the content generation function and the research function of generative AI because they both offer different benefits to users, and users are going to have different expectations about what the output should look like, depending on which of those goals they're pursuing. We might also make legal and ethical distinctions between the content generation function and the research function. Um, so when users are doing research, they could be harmed if the outputs that are produced by generative AI contain errors or if they're tortious or illegal, and if they rely on those outputs uncritically. But because they're doing research, we could also imagine that we're going to put the burden on them to be a critical consumer of that information and to do take the legal and ethical responsibility to actually investigate the materials themselves. Now, when people are generating content using generative AI, it's even more obvious that they can review the outputs, they can modify them before amplifying those results. And that includes fixing any errors, that includes fixing any legal problems. And so with respect to either the content generation function or the research function, users have substantial agency in how they evaluate and disseminate the materials, and that agency has some potential legal significance. So despite the baggage associated with the AI nomenclature, generative AI's content generation and research functions both lead to the production of content that we might call, to use a magic legal term, publication. Now, we really struggle with figuring out what it means to talk about publication in generative AI context because there's at least 4 different paradigms about how we might assign the ethical and legal responsibility. One paradigm is that the generative AI model is publishing content to prompting users, and that means that the model operator is legally responsible for all the things that they publish, but it would also potentially mean that they're eligible for the First Amendment protections that apply to content publication. A second paradigm is that the generative AI model is executing the user's prompts to generate the requested content, kind of like an agent, but in which case the user is the one taking legally significant action and bears the resulting liability. Another paradigm is that the generative AI model and the users are some kind of co-creators. They're both involved with each other in some kind of hybrid status, and we don't necessarily even have a good, clear legal precedent for that. And then finally, we could take the position that the generative AI outputs are the responsibility of neither the generative AI model or the prompting user. I call it kind of like a deus ex machina origin story for the content. This issue about agency and responsibility, I'm going to come back to in part 3. But it's part of the reasons why the conversation here gets so clouded because of the fact that we aren't even sure which of the models describe the interactions. Okay, I'm going to turn to the second part of my talk, which is a feeling of deja vu that I experienced watching the generative AI epiphany. So back in 1994, I had a front row seat to watch the dot-com boom and the emergence of a commercial internet. And it was a really exciting time. There was a ton of excitement about the potential for the internet to benefit humanity. So in 1996, Congress said, and I quote, "The rapidly developing array of internet and other interactive computer services available to individual Americans represent an extraordinary advance in the availability of educational and informational resources to our citizens." Now, a note about this slide. I asked the concept for DALL-E to create an image of people celebrating the arrival of baby internet. And turns out DALL-E doesn't like depicting babies. And this is part of its trust and safety efforts, I believe. So I had to come up with a new metaphor for baby, and I chose Nyan Cat. And I have no explanation for that other than I love Nyan Cat. And so every time Nyan Cat makes an appearance here, imagine that the generative AI would have actually produced baby internet for me. Okay, so it's going to be very hard for many of you to imagine today, but back in the 1990s, regulators often took a deferential and hands-off approach to regulating the internet. Now, this was partially fueled by prevailing concerns that overly aggressive regulatory interventions would distort or harm the emergence of important new innovations. Congress said in 1996, its policy was to, quote, preserve the vibrant and competitive free market that presently exists for the internet and other interactive computer services unfettered by state or federal regulation. It really was a remarkable time period of regulator humility. Back in the 1990s, regulators knew that they couldn't anticipate all the different things that the internet could do, that we have now seen over the last 3 decades, and they couldn't anticipate what kind of benefits would come from those things. If the regulators had hard-coded their conception of what the internet meant circa 1990s into law, the internet wouldn't have achieved the outcomes that we're seeing today. And I think the world would be poorer for it. So in the 1990s, the regulators admitted that, and they actually chose regulatory forbearance. Generative AI is not going to get the same reception from regulators. They're intervening today based on their unenlightened views in the 2020s of conception of what generative AI can and do. But we don't know everything generative AI can and do, and that's going to be clear only over time. And so the interventions we're making today will inevitably restrict generative AI's potential upside. I do need to mention a couple things about this image. Some of you may know, just was really blown away. The longer you look at generative AI images, the less sense that they make. So I asked generative AI to make an image of a politician carving up a robotic turkey. And DALL-E doesn't like knives. So it couldn't actually show the carving up of the turkey. You'll see that somehow we got, the server has robotic hands, because I don't know. And here's another example where we have the bias towards the white males. Okay, so let me give you some data about this regulatory naivete. The European Union recently adopted a important new law, the AI Act. And in 2022, just as we're on the eve of the generative AI epiphany, the AI Act was nearly done, but it hadn't contemplated generative AI at all. So the drafters were working for years to come up with this brand new regulation of the internet, of AI for the future, and they literally had a blind spot at what they didn't even know was literally going to drop on them in a matter of days. That's why I said you can see around the corner. I don't know that this image actually fully reflects that, but what I do think is likely is history is going to look back at the AI Act and say, wow, that really was myopic. They did not anticipate everything that was coming. So the problem is that we're not just talking about a few miscrafted laws here or there. The regulations are coming as a tsunami. And according to Business Software Association, state legislatures introduced over 400 AI-related acts in the first 38 days of 2024, nearly 6 times as many as that have been enacted during that time period in 2023. Now, not all these bills are going to pass. Some of them already have, and more are coming. And so I describe it as regulators flooding the zone. The AI regulation is coming hard now, and each bill represents its own independent threat to generative AI's innovation arc. So what I've been trying to do in preparation for this talk is think about the disparity between the 1990s regulatory deference to the internet and the 2020s regulatory tsunami that's crashing down on generative AI. I'm going to give you 4 hypotheses, not mutually exclusive. There are probably others. This is what I've been able to come up with. Hypothesis number 1, that the internet and generative AI are on different regulatory tracks because of the way that they have been treated in the media before they became mainstream. So in the 1990s, people generally had never contemplated a global, decentralized electronic medium like the internet. Um, if you look at old versions of sci-fi, almost none of them contemplate the internet or anything quite like it. In fact, usually the sci-fi stories turned on information scarcity. That was the driving plot point. So what that meant is when the internet arrived, there hadn't been this socialization of the internet as a dystopian technology. It just really hadn't even been contemplated. Now, you do know that's different from how we've treated AI in the media generally. So AI has been the subject of dystopian books and movies for decades, and usually the AI is depicted as something that poses a threat to human. And if you watch the old movies, invariably the AI turns murderous. It's not just going to hurt us, it wants to kill us. And it doesn't matter that generative AI is not autonomous here. Like, that just doesn't matter. As long as we're linking AI and generative AI, we're linking into these psychologies that we should be conditioned to fear it. And so as a result, generative AI never got the honeymoon period that the internet got. It didn't have that kind of lack of reputation. Okay, second hypothesis I've got for you to explain the dichotomy response is similar to this media conditioning point, but it's really related to the attitudes generally about technology. There was a techno-optimism in the 1990s across all types of technology, a celebration of how ingenuity and innovation could improve society. The internet was welcomed as new, important, and beneficial. In contrast, the generative AI epiphany occurred during a strong wave of anti-technology sentiments, what I and many others sometimes call the techlash. It's a portmanteau of technology and backlash. Many people today are angry about technology generally, and they're angry about big tech specifically. They blame technology for all of our social ills. And so before we got generative AI launching, we were already primed to dislike it as part of the reasons that we hate technology generally. And this is especially true because many of the big generative AI options are associated with the highest profile big tech companies. Okay, a third reason why to explain the dichotomous treatment is the current environment of heightened partisanship. Now, partisanship is not new. There was plenty of partisan games back in the 1990s. And for whatever reason, and I still don't have a good explanation for this, the internet avoided a lot of that partisan rancor during the 1990s and into the 2000s. In fact, it really didn't get enmeshed in the partisan fray until about a decade ago. Nowadays, everyone is on heightened alert for partisan bias online. And whatever the technology is, every new technology is going to be accused of political bias, and there's going to be cherry-picked anecdotes depicting that. It's not because the tools are actually biased, it's because the publication process, any content publication process, necessarily prioritizes some content over others, and that creates ways to establish a dichotomous treatment that produces anecdotal evidence showing that there's some bias that the critics will cherry pick if they disregard proper scientific methods. So generative AI is producing these evidence anecdotes of partisan bias, and partisan advocates are seizing upon that to advocate for sensorial interventions into generative AI to favor their team and disfavor the rival team. This partisan buzzsaw that generative AI is going to be run through is an existential threat to it. And it's an existential threat to every publication technology, and that includes the internet as well. All right, another example of how Dolly couldn't handle the babies. Okay, the fourth and final reason I'm going to discuss for the possible disparate treatment in the technologies is what I'm going to refer to as incumbency. When the internet arrived in the mid 1990s, it didn't have incumbent players. The leading players at the time were websites and commercial online services like AOL, and they were just relatively small, all things considered. In fact, the biggest commercial players at the time were the telecommunications company who offered internet access, and they didn't really care so much about trying to manipulate the regulation in their favor. All they cared about was getting new customers. So during the 1990s, we didn't have any incumbents who were interested in seeing more regulation. There was generally a strong norm against it. This is not true today. The generative AI epiphany was triggered by a single company, OpenAI, that has raised $13 billion and has a valuation of over $80 billion. The other big tech giants are involved in generative AI as well: Microsoft, Google, Facebook, Amazon. They're spending tons of money on as well. So the fact that so many giant players are spending so much capital in this area makes me think of the sport of polo, which you may know has the nickname the sport of kings, because you can only afford to play the game if you're royalty. Now, before I turn to the implications of these two different treatments, I want to make two more points about the impact of having incumbents in the generative AI industry as it proliferates. The first thing is that unlike startup companies, incumbents don't always disfavor regulation. Sometimes they come out in favor of it. And that's because if they have the money, they view it as a cost of doing business, just like all the other regulatory costs that they incur. So from their perspective, it's not necessarily a bad thing to raise the overall cost of being in the industry if that's a way of suppressing new entrants by preventing them from being able to afford the costs. Now, certainly the incumbents in the generative AI space have the muscle to push back on regulatory interventions and protect the industry from overregulation in a way that the internet companies circa mid-1990s didn't have the power to do. But that assumes that the generative AI companies are going to oppose it. And in fact, as some of you may recall, OpenAI has openly called for additional regulation, as have many other players in the generative AI space. And this doesn't prove that their calls indicate that regulation is in the public interest or that it's even a good idea. It's most likely a call for additional ways to restrict competition. And unfortunately, many regulators are just dandy with playing ball with those calls because they view it as a way of them doing something, even if they're being played. The second thing that matters about the presence of generative AI incumbents is that I think it's more likely that we're going to see a content licensing scheme emerge in generative AI than we had in the internet context. So let's just talk about circa mid-1990s. When the commercial internet launched, we assumed that the internet was going to look a lot like cable TV. What I mean by that is that there was going to be databases of professionally produced content that we as consumers would pay a subscription to access. And we had a miracle. Instead of having that, we actually had the development of the Web 2.0, a quarter century era where we had user-generated content, or UGC, that companies typically obtained without paying licensing fees. And because they didn't have to pay the licensing fees, they could explore business models other than charging for subscribers for a subscription. Now, the same kind of content acquisition strategy, a free strategy to acquire content, is still, I think, possible for generative AI models. They could still index third-party content to create their models without paying licensing fees or obtaining copyright permissions. And the reason why I say it so confidently, some of you may know, the Google Books case that held that services don't infringe on copyright when they index third-party content and use it to create non-infringing outputs. And that's usually going to be the case with generative AI. Now, there are some other legal entanglements I note. trespass chattels and contracts being among them. But from a copyright standpoint, there's a relatively solid precedent suggesting that the companies could acquire their content for indexing without a licensing fee. And yet, it's possible, and in fact, probable, that the generative AI incumbents are going to accept or even prefer an industry standard that includes paying licensing fees to index content. And this is just like my discussion about the other compliance costs I mentioned earlier, that this is just another cost of doing business. This is a cost that raises the cost across the entire industry, and therefore acts as an entry barrier to rivals. So OpenAI has already indicated a willingness to pay licensing fees in order to acquire content from major copyright owners. And in fact, if OpenAI does go that route and does start paying, I guarantee you that OpenAI will be the biggest proponent of copyright reform that requires everyone else in the industry to pay for licensing fees as well. Okay, let me step back for a moment and say that I haven't given you a single causal explanation for why we're seeing a different treatment of generative AI compared to the internet. But let me reinforce my descriptive claim. We are experiencing an epochal shift in technology on the order of the internet's commercialization, but this time the regulators are intervening early in a massive and unrelenting way. Sorry. Okay. I'm now going to turn to the third and final part of my talk, where I'm going to anticipate how this regulatory tsunami is going to shape the future of generative AI. But I think you already have a prediction of where I'm going to go. I will reiterate, my talk title is Generative AI is Doomed. So I have three subparts. First, I'm going to explain how and why regulators are going to kill off generative AI. I'm going to explain how and why those interventions will have negative consequences for all of us. And then I'm going to give you some unrealistic thoughts of how we might be able to hypothetically avoid those consequences, but the regulatory tides cannot be stopped. Earlier in my talk, I explained the four differences between the 1990s internet and the 2022 generative AI epiphany. I'm going to add a fifth difference now, which is the US regulatory context. So in 1996, shortly after the internet's commercial launch, Congress enacted 47 USC 230. It's an extraordinarily powerful powerful legal immunity. And in short, Section 230 says that websites aren't liable for third-party content. And this very simple but elegant legal principle reflected the 1990s techno-libertarian ethos about internet exceptionalism, that the internet was different and therefore it required different treatment from other types of media. Now, Section 230, websites aren't liable for third-party content, has become the legal foundation of Web 2.0, the era of user-generated content that's provided for free and provided under alternative business models. And it really established the primacy of the user-generated content model. And if you look at lists of top 10 most frequently used websites or services here in the United States for many, many years, every single one of them depends on user-generated content in a fundamental way, which has meant that by implication, all of us are depending on Section 230 all of the time. And for those of you who are multitasking right now, I bet you're depending on Section 230. Now, Section 230 also had a secondary effect, which is that it discouraged state lawmakers from passing laws trying to regulate user-generated content because those laws are likely to be preempted by Section 230 of federal law. So Section 230 preempted or prevented this regulatory tsunami from occurring in the 1990s directed at the internet. Now, Congress has not adopted a law analogous to Section 230 that expressly shields generative AI. And so we're not going to see the same kind of regulatory dampening effect that Section 230 provided for the internet to benefit generative AI. Now, in addition to Section 230, the internet benefited from favorable constitutional interpretations from the Supreme Court. And in 1997, the Supreme Court declared, and I quote, "The internet is a unique and wholly new medium of worldwide human communication, and because of that, it deserved the highest levels of First Amendment protection. That constitutional interpretation surely also contributed to discouraging 1990s lawmakers from pursuing internet regulation. Now, it remains to be seen how the Supreme Court will handle generative AI. It's possible that it will get equally vigorous constitutional protection from the US Supreme Court, but I'm not betting on it. First of all, as I mentioned, there's this open question about the agency. Who creates generative AIs? Is it the query submitter, the model maker, both, neither, someone else? This question is being hotly debated in the literature, and it's surely going to affect the First Amendment's application until it's definitively resolved and clear who is responsible. Regulators are just going to proceed as if the First Amendment doesn't apply to generative AI. And if you look at the bills that have passed to date, they only make sense if you're assuming that the regulators believe that generative AI does not qualify for First Amendment protection. They're just going for it. In addition, the 2020s Supreme Court may not reach the same conclusion as the 1990s Supreme Court did about the internet itself. That question is going to be posed to the Supreme Court. It's pending before, there are several cases pending before the Supreme Court today, where the Supreme Court could do something very different. Why might it be different? Well, the Supreme Court has changed its composition. The Supreme Court has shown that it's willing to revisit longstanding precedent, and the Supreme Court can't ignore the prevailing popular sentiment against the internet. So given the ambiguities over the agency question I mentioned and the possibility of changing the Supreme Court, I just don't see why generative AI is going to get more favorable constitutional treatment than the internet did. Okay, so I've made the argument that generative AI won't benefit from the liability shields of Section 230 in the Constitution. If that's true, then regulators have a virtually limitless set of regulatory options to dictate every single aspect of how generative AI works. Your imagination cannot contemplate it all. But I'm going to mention 3 different types of potential regulatory interventions that they might pursue. First, there's the stupid regulations. They're going to pass laws that reflect a misunderstanding of the technology or that are driven by moral panics and not facts. The second is the censorial regulations. Without the strong First Amendment protections for generative AI, regulators are going to seek to control the outputs to favor their preferred narratives. So we already get a sense of what that's looking like with the state efforts to regulate the internet. Although we have the First Amendment, although we have Section 230, regulators are actively seeking to dictate every aspect of internet services, editorial discretion, and operations. Now that's pending before the Supreme Court today. There will be more court cases coming. But if generative AI never receives strong constitutional protection, then regulators are going to embrace the most invasive and most censorial approaches. There will be no barriers to doing so. And the third category of regulation that I want to mention is just partisan regulations, where the regulators steer generative AI outputs to advance their partisan agendas. We're already seeing this type of partisanship in the efforts to control public discourse on many topics. Vaccines, transgender issues, abortion, these are all partisanized topics where the regulators are trying to control the flow of information so that they advance their partisan agendas. All these culture wars are coming for generative AI, and if there's a weak constitutional shield, then generative AI has very little it can do to defend itself. I will note the heightened risk of that in what are the trifecta states, where a single political party controls the legislature and the governor's office. They don't have the same kind of checks and balances in their efforts that we expect would otherwise curb partisan motivated legislation. If you aren't aware of it, 40 states today are trifecta states, 23 Republican, 17 Democrat. Okay, so we've got the dumb, the censorial, the partisan attacks on generative AI. And even if we didn't have any of those, generative AI industry is going to be overwhelmed just by the sheer volume of regulation, and especially if the state laws aren't standardized. So Section 230 kept states out of the business of coming up with their own idiosyncratic regulations, which meant that internet services generally only had to worry about complying with a single national federal standard. If we don't have the national federal standard for generative AI, then the compliance cost goes up even further. The sport of kings problem becomes even bigger. Okay, so to recap, I expect regulators will intervene on every aspect of generative AI's editorial decision-making, from the mundane to the fundamental, for reasons that range from legitimate to completely illegitimate. Those efforts aren't going to be curbed by any public opposition in favor of generative AI. They're not going to be curbed by Section 230. They're not going to be curbed by the First Amendment. And the regulatory frenzy is, I think, going to be shocking to most of us, that we've never really seen when legislators go for it in regulating a topic that involves the publication of content. It's going to be dramatic, and it's going to change the industry if it survives at all. Now, I already mentioned some of the benefits from the content generation and research functions of generative AI. The regulatory tsunami is going to wipe those out or render them useless. I also think we're going to lose these potential benefits that emerge from the iterations over time. Usually when regulators intervene early into a technology, we never know what could have been. And the regulatory tsunami is going to create collateral damage beyond just generative AI. For example, regulators struggle to define generative AI without also including algorithms of all types. So if you have malicious or misdirected generative AI regulations, they put in play things that we take for granted today, personalized content to algorithmic search. All of those are things that we rely upon every day, and all those might be swept in under the aegis of generative AI regulation. If it does survive, the generative AI industry is going to contain likely a small number of large players due to the compliance costs. And this has its own downsides. It means we'll have concentrated industries that are less innovative and dynamic because fewer new entrants are around to push the giants competitively. That costs are going to be higher because consumers will have fewer choices. And the incumbents are going to have so much power that the regulators are going to get feel pressure to keep intervening. It's like a negative regulatory feedback loop. The increased interventions raise costs. The power gets consolidated further into a smaller number of players, which increases the incentives for regulators to keep intervening. It brings me no joy to deliver a bleak talk. And it's even worse, I have no good ideas of how I can lead us to a better outcome. Calling attention to the problem is a start, but it's not going to move the needle against decades-long socialization against AI and the plays by incumbents to co-opt regulators to erect regulatory barriers. In a hypothetical timeline with a different Overton window, Congress might enact statutory immunity similar to for generative AI that's analogous to Section 230. That wouldn't necessarily end the regulatory tsunami, but it would delay it and defer it. It would keep the industry more dynamic. And in the timeline that we occupy, not in the fantasy land I just mentioned, the idea that regulators would take any affirmative steps to protect generative AI is just an ivory tower thought. It would help to rebrand generative AI to distance it from AI if we were more expressly acknowledging the content generation and research functions of generative AI. That might reduce public fear, might make the benefits more obvious, and might make the Constitution's application more obvious. So on that front, I can make a request of you to critically scrutinize every effort that you see to regulate generative AI. Don't assume that those efforts are being advanced for your benefit. Don't assume that they're being done for legitimate reasons, and don't assume that they're being done in a constitutional manner. And once you start noticing all those problems, I think you're going to be better positioned to hold the advocates more accountable. And on that incredibly tiny, hopeful note, I'll end my remarks and open it up to your comments and questions. Thank you so much for joining me today.
We do have a few minutes for questions, and so if you have one, all the way in the back, if you can stand up and say it as loudly as possible. Yes, please.
Hi.
We can hear you.
On the European Union's already existing regulations, especially around competition, to maybe rescue some of this generative AI?
Thank you.
So the question is, do we get some kind of halo effect or benefit from the efforts that are taking place in Europe? And I think the short answer is no, although I recognize there's some nuance to that. But let me give you a couple of reasons why the answer might be no. The first is that, for example, the GDPR has been shown to actually restrict competition. It has actually raised entry barriers and caused there to be a shrinkage of overall entrepreneurial activity in the EU. So it actually is an evidence of the concerns I have, not actually a savior. But I think the more important piece is that the EU doesn't have the First Amendment. And they also don't have the same degree of homegrown generative AI solutions that are here in the US. So they don't care as much about this issue as we do. So to think that they're going to advance American interests in the process is, I think, unrealistic. They're just operating on a different set of problems that don't reflect our lived experience. So, there may be halo benefits I haven't mentioned, but to think that the EU is our solution here is really, I think, the wrong direction for us. I think they're the threat as much as the solution.
So strike one on the effort to get Professor Goldman to demonstrate some optimism. Yes, please.
It's going to be a very strange analogy, and I'm not a legal bent. But it's very similar to that question. If you look from a European standard or a non-US standard, the analogy would be online poker, meaning the laws, those that are playing online poker in the US generally are breaking the law, but there are also kind of waivers that you are doing business in a sovereign nation elsewhere. And could you get services delivered from another sovereign nation?
Thank you.
So I guess I'm a little bit unclear about the question. Are you suggesting that the big incumbent generative AI companies are going to move offshore and thereby avoid the regulation that's coming for them in the US?
Or that would imply that the small guys become big guys by hitting them where they aren't.
Okay, and I'm sorry, you're not going to get any optimism on that one. Let's just start with the most important thing. There's a very small pool of really talented AI engineers, and they're mostly here in the US. So to get them offshore to avoid the scope of US regulation seems extremely unlikely. There's a fair amount of network effects from the development of AI where you need to have the right teams, and those teams aren't likely to move in toto. So I don't think you're going to get that. But even if that were true, we're the US. Nobody evades our laws. And so, we'll find a way to make sure that anyone's big enough to matter is going to do it by our rules.
Let's take one last question, please.
The EU frameworks will impact us because of the extraterritorial effect that their laws have on our businesses that are doing business there. The AI Act, GDPR.
Yeah, so even if we were to do nothing, the EU's developments are going to impact the future of our US generative AI solution. So that's absolutely true. But what we're doing here is probably not even as good as what they're doing in terms of thoughtfulness. And so if we're in the business of manufacturing laws, whatever benefits or implications we have from there, we should be worrying about, the call is coming from inside the house.
Except that the insurance industry has done something interesting, putting forth their principles for regulation, for model law.
Yes, but as you may know, there's been kind of like a race to the bottom type thing. If the EU is doing it, if China is doing it, we better do it too, but we'll do it our way. We're not going to do it their way.
I see lots of other hands. We do try to do this within an hour. And so let me say several things. First, I understand that Professor Goldman is going to publish his paper, and we may define publication in a number of ways, as he says, but I do expect that it will be available on the internet relatively soon, and we will be glad to send out a link to everyone in attendance. Second, I want to say that while we do keep the event in the room to an hour, we have a reception outside, and I know that Professor Goldman is not running away. He's not that kind of guy. He is more than willing to engage with folks and to engage with your views. So do join us in the reception in the Zilber Forum. And third, I want to say thank you. Certainly, I want to say thank you to all of you for coming out on an April afternoon or evening, the busiest time of the academic year, and for engaging with us. And surely, most of all, I want to say thank you to Eric for returning to us, at least briefly. This was wonderful. Thank you.